I'm Mark Stobbs. I'm Director of Scrutiny and Quality at the Professional Standards Authority, and my team looks at the overall performance of the regulators and it looks at their fitness to practice decisions. Now, fitness to practice is the shorthand term we use for the process regulators have for investigating complaints about their registrants. And those complaints might cover clinical mistakes, health problems that the registrant may have, language problems, or sometimes conduct outside practice, for example, if they've committed a serious criminal offence. The regulators will investigate those initially, and they will decide if the case is serious or not. If it is serious, they will send it to a panel, and the panel will look first at the facts to see whether the registrant actually did what's alleged. Then they decide whether it amounts to misconduct, so is it serious? Then they look at the registrant now, because often this happened 2 or 3 years ago, and the registrant may well have thought about it, improved their practice, made changes, and the regulator may well say, that's fine, we don't need to worry about you anymore. But in cases where the registrant hasn't done that, or where there are real concerns, the panel has a number of things it can do. It can impose a caution or a warning. It can impose conditions on the registrant, so the registrant might have to practice under supervision or take some courses. It can suspend them for up to a year, or in the most serious cases, it can strike them off, erase them, so they can't practice as a professional again. This is where the authority comes in. We have a process which we call the Section 29 process. That's after Section 29 of the National Health Service Reform and Healthcare Professionals Act 2002. That's the section which gives us the power to refer decisions of panels which we think aren't sufficient to protect the public to a court. We look at every single decision that a regulator takes. That's about 3,000. And most of them are fine. But in about 150, 200, we look at them in more detail because we don't understand why the panel has reached the decision that it has. So we ask for the papers, the transcripts, and we study those. We'll also get some legal advice to see whether a court would agree. We refer about 20 every year. So you could see it's a very small number, but these are cases which are usually very serious. The court can either substitute its own sanction, so it can strike somebody off or impose different conditions if it thinks the panel just got that wrong. Or if there are more complex matters that the panel got wrong, it can send it back to the regulator and ask them to look at it again. We will also send learning points to regulators if we don't appeal cases, but still think there was something wrong, and we hope the regulators will use those in their training of panel members and in the guidance that they give them. The authority doesn't take many cases, but the cases that we do take are very important. They establish case law, they provide guidance to the regulators, and we hope also that they're successful in making sure that the public is properly protected from the very few registrants who shouldn't be on the register.